To call on Professor William C. Banks, who is recognized internationally as an expert in constitutional law, national security law, and counterterrorism. Since 1987, when the Federation of American Scientists asked him to provide a legal perspective on the first use of nuclear weapons, Banks has helped set the parameters for the relatively new field of national security law. Working with Stephen Dicus, Arthur Burney, and Peter Ravenshazen, Banks wrote the leading text in the field. National security law was first published in 1990 and is now in its fourth edition. And there has been another publication, Counterterrorism Law, in 2007 to help define the emerging field of counterterrorism law. Banks is also the author of numerous other books, book chapters, and articles, including Constitutional Law, Structure and Rights in Our Federal System, 5th edition, The Death of FISA, Legal Sanctuaries and Predator Strikes in the War on Terror, and Targeted Killings and Assassination. Banks' current research interests include domestic and international terrorism, emergency powers, war powers, emergency preparedness and response, civil military relations, and appropriations powers. A graduate of the University of Nebraska in 1971 and the University of Denver, JD, 1974, Banks joined the faculty of Syracuse University College of Law in 1978. Since 1998, he has also been a professor of public administration at Syracuse University's Maxwell School of Citizenship and Public Affairs. He was named the Laura J. and L. Douglas Meredith Professor for Teaching Excellence in 1998, and he became the founding director of the Institute for National Security and Counterterrorism at Syracuse University in 2003. He also served as a special counsel to the United States Senate Judiciary Committee in 1994. Banks worked with the committee on the confirmation of hearings for the Supreme Court nominee Stephen G. Breyer. It's also a pleasure to note, Professor Banks, that you played a very, very crucial role in the signing of an exchange program between the Maxwell School and IDC Herzliya. I'm very pleased that in the front row we have Jerry Kramer. Please stand, Jerry. Jerry Kramer has made possible this exchange program between the Maxwell School and IDC Herzliya, the Lauder School of Government, and there's nothing more pleasing than seeing 20 fine students from Syracuse University under the eucalyptus trees of our campus here studying counterterrorism, and 20 students from IDC Herzliya coming to Syracuse to exchange views and to have students studying counterterrorism together, exchanging views and teaching these youngsters at a very, very early age the art of counterterrorism. And I think that's a very, very, fine commentary. Professor Banks.
Good afternoon, and thank you, Jonathan, for those kind words and for the comments about our joint program. For those of you who like to connect dots during the course of a conference like this one, my comments this afternoon sort of trace from General Clark's opening speech last night through Boaz Ganor's discussion this morning about the definition of terrorism. Whoops. Here we go. Following a signing ceremony in the Netherlands 100 years ago, on October 18, 1907, the Hague Conventions respecting the laws and customs of war on land required states to issue instructions to their armed forces in conformity with the present convention, and another article made clear that the rules of the convention applied only to wars between the states' parties. In addition, the Hague Convention's rules for conducting war apply only to a subset of the states' parties' nationals, those defined as lawful combatants, a category that had gradually evolved in customary law and some earlier treaties from the pre-Middle Ages and Middle Ages practice of treating all inhabitants of a state as enemies. In short, the laws of war developed on the basis of one conception of war, assuming symmetric conflicts between state armies of relatively equal strength and of comparable organizational structures. Of course, conflicts may also be asymmetric. We've heard about those today, and you've all been aware for a good long time. They involve typically attacks by non-state entities against sovereign states. Yet the law continued to do little to accommodate the asymmetric form. Almost 60 years ago, following extensive revisions to the laws of war, in the Geneva Conventions, nations of the world, the decision makers or military leaders, understood that the articles of those conventions constituted the exclusive criteria for triggering the laws of war that were further detailed in the conventions and in other positive and customary law. Under Geneva, there were only two kinds of wars: interstate or international armed conflicts and intrastate or internal armed conflicts. The former invoked the full panoply of the laws of war, which in turn regulated the conduct of that war: distinction, proportionality, military necessity, while the latter did not trigger the regulations for the conduct of war, but provided for limited humanitarian protections for those who were captured or detained. The Geneva Treaty provisions, deliberately excluded non-state actors, first by providing a regulatory scheme only for wars between states, except for the minimal protections afforded those involved in non-international armed conflicts. Second, the Geneva Convention criteria for deciding who is a lawful combatant also were written to reach only state soldiers. Requirements that include, as many of you know, a responsible command structure, wearing a fixed insignia, recognizable at distance, carrying arms openly, and conducting operations in accordance with international humanitarian law. It was they who gained POW status under the conventions. It's virtually impossible for non-state actors to meet those criteria and thus become lawful combatants under IHL. In addition, because IHL includes a combatant's privilege, a form of legal immunity for acts that would be criminal if performed during peacetime, non-state actors may neither engage in lawful combat nor be its deliberate target. So, to summarize the conventions, to invoke the laws of war and the humanitarian provisions that are part and parcel of those laws, there had to be an armed conflict within the meaning of the Geneva Conventions, and that armed conflict had either to be international or non-international. Although the conventions do not define armed conflict, that part of the triggering mechanism has not been difficult to implement. The understandings about what constitutes armed conflict are relatively clear. If the armed conflict threshold was not met, the laws of war could not apply. If it was, and it often of course has been, the laws of war would still not apply unless the conflict was state versus state or internal, a civil war. As we all know, determining the existence of non-international or internal armed conflicts has not been an easy one. Many internal conflicts are civil disturbances, are amenable to domestic laws, but others rise to the level of armed conflict and should be governed in some way by the laws of war. At the same time, under the traditional laws of armed conflict or international humanitarian law, many asymmetric conflicts where relatively weaker non-state belligerents attack a stronger state are not wars under the conventions either. There's no state versus state conflict. Nor are the laws of war applicable to a war against terrorism. There's no state enemy. Of course, in practice, it would not be possible to implement the basic IHL principles of distinction, proportionality, if commanders and soldiers could not readily distinguish civilians from soldiers. Although these threshold principles are not necessarily morally required, they're central to implementation of the conventions and their terms. Today, asymmetric war is a central feature of 21st century global affairs, and yet the prototype asymmetric war involving a non-state actor falls outside IHL. So the absence of a set of rules to govern asymmetric warfare presents a serious problem for states who require guidance in conducting their military operations and for those who are otherwise victimized by those kinds of conflicts. In the decades since 1949, a good deal of work has been done to modernize the status categories from this model of IHL. One approach that has been proposed is to apply a principle of protective parity to all who participate in armed conflict, regardless of their compliance with the criteria for lawful combatant status. Others have recommended that the test of combatant status should simply be functional. Is the person actively involved in planning or carrying out acts of violence? Applying traditional IHL, members of Al-Qaeda who are not in some way affiliated with the armed force of a state, such as the Taliban, cannot be combatants, as that term is understood in international law, nor could war or armed conflict be applied to the September 11 attacks by Al-Qaeda operatives, although, of course, those heinous acts violated international and domestic laws. In the decades after 1949 and before September 11, states came to realize that the dominant form of armed conflict was internal, civil wars or insurgencies, and that the failure to anticipate non-state armies and incorporate them in some way into IHL would disserve the humanitarian interests of the policies and laws. In the mid-1970s, states designed Protocol 1, which sought to accommodate then-current national liberation movements that were viewed as fighting just wars against colonial governments. That protocol provided that international armed conflicts could include these NLMs. It relaxed the criteria for obtaining POW status, and it permitted the non-state actors to join, if you will, IHL by formally declaring their intention to do so. Many states resisted these changes, as we all know, for a variety of reasons, including that the protocol could be construed to give rights to terrorists. Over time, decolonization slowed to a trickle. The protocol debate became quite academic. No group made the declaration contemplated by the protocol, and no individual or non-state group has sought or been afforded IHL treatment under the protocol. Shortly after the September 11 attacks, the Bush administration characterized its response as a war. There was wide-ranging and bipartisan support in the United States and elsewhere, of course, for the basic idea and eventual policy that the United States was at war with a transnational, non-state entity, wherever that entity might be encountered, the so-called global war on terror. While the phrase has emotional power, continues to reverberate, calling the counterterrorism policies of the United States a global war on terror has actually sowed the seeds of legal and policy confusion and may have set back the cause of bringing legal regulation to asymmetric warfare. This is not because terrorists and insurgents are incapable of making war. We all know the opposite. Indeed, whether we view terrorism as a crime or war or both of these things or something else altogether is simply a policy preference. Or to use Michael Walzer's phrase, war is, quote, something people decide. The problem that the project here, the New Battlefields Old Laws Project, is examining is that the legal framework for regulating war does not contemplate asymmetric warfare waged by non-state actors and thus fails to regulate perhaps the dominant form of warfare, at least in this part of the 21st century. Because the use of military force will surely be a policy option for countering terrorism and other forms of asymmetric warfare for the foreseeable future, we believe it's high time that IHL recognize this reality and adopt to it. The legal picture was further obscured when in early 2002, then White House counsel Alberto Gonzales wrote that the war against terrorism is a new kind of war and that the new paradigm renders obsolete Geneva's strict limitations on questioning of enemy prisoners and renders quaint some of its provisions. The Bush administration detained individuals at Guantanamo Bay, prepared to try them by military commission. Through those procedures, after applying new standards from the metaphorically powerful but legally boundless global war on terror. Because some of the detainees were not seized on a traditional and legally recognized battlefield, their detention and military confinement was itself legally questionable. Matters have been made worse by their being labeled, quote, unlawful combatants. With the exception of captured Taliban fighters, those detained at Guantanamo do not fall within the definition of combatant of any type. Enemy, lawful, unlawful, they are simply unprivileged belligerents and are thus amenable to prosecution in U.S. domestic or military courts for war crimes. As the U.S. Supreme Court agreed in 2006, the armed conflict with al-Qaeda is a non-international armed conflict to which the humanitarian provisions of Common Article 3 apply. Beyond this quite minimal coverage, IHL is of little or no guidance in asymmetric war involving non-state actors. Why bother attempting to extend the laws of war to conflicts with non-state actors, whether terrorists, international criminals, insurgents, or something else? One reason is to provide any state that finds itself in such a conflict notice that the rules apply, including the human rights protections that apply during war. In a military sense, combat may be waged only within the requirements of military necessity. Yet it's always been thought that the laws of war would not be available to protect an enemy that is not deserving of protection. Why glorify an undeserving enemy and elevate his status to his own constituents? Scholars have warned that affording a protected status to insurgents or terrorists, for example, might lend legal and moral legitimacy to acts of violence against the state. Some have suggested that rather than recognizing conflicts with non-state groups as international armed conflicts, that they be seen, as the U.S. Supreme Court and some scholars have viewed them, as a species of non-international armed conflict, so that only those limited protections of Common Article 3 might apply. One problem with this approach is that Common Article 3 speaks only to the treatment of persons captured and does not regulate the military operations themselves. In addition, if you think about it for a moment, this approach is also belied by the text of the conventions because asymmetric conflicts are typically transnational. It would diminish the value of the conventions to label a clearly transnational conflict as non-international. Others have maintained that IHL works well enough and ought to be left alone. For these people, now I'm thinking of General Clark, terrorism is simply a crime, even if it's sometimes heinous and massive in scale. States should apply their domestic criminal laws to apprehend, arrest, prosecute those who engage in terrorist acts against the state. To the extent that states are unable to enforce their own laws, an international force might be created to help enforce domestic criminal laws. Our project, the New Battlefields Old Laws Project, rejects the idea that domestic criminal law should be the only strategy and means for countering terrorism and for regulating terrorism and other forms of asymmetric war. We also begin with the view that the existing IHL system is a good one that is worth considerable effort and compromise. With these considerations in mind, how can the convention-based laws of war be adapted to asymmetric warfare? How can the conventional be revised to account for the unconventional? If the fighters on one side lack the recognized structure of professional armies, and thus the discipline and structures of authority, how could the non-state entity enforce the rule of law if they were so extended? If the non-state actor repudiates the basic principle of IHL, non-combatant immunity, how could IHL be applied to all their activities? For openers, we're very free to concede any effort in this regard will necessarily be one-sided, at least in the beginning. States will have to take the lead. The prototypical non-state actor, al-Qaeda, rejects the principles of non-combatant immunity and distinction. Bin Laden has maintained, of course, that it's acceptable to kill non-combatants because they share responsibility for the harms allegedly suffered by Muslims at the hands of the West. To this extent, the adaptation of IHL has to proceed while one party to the conflicts under consideration rejects the core principles. Moreover, al-Qaeda and similar groups are only loosely aligned in a network sort of fashion. There is thus no traditional command or hierarchy that could be accountable for IHL compliance, monitoring, or training. There are no clear points of reference for negotiation, effective deterrence, or reciprocity. It's clear that any adaptive scheme for IHL will necessarily have to be voluntary in the beginning, incentives built in for joining and complying, even though it's unrealistic to expect non-state entities invited to join an adopted IHL to comply reciprocally with states with IHL understandings. Even modest gains in IHL compliance by states and non-state actors would be worth the effort toward adaptation. Knowing full well that the time is short this afternoon and that we have a very full panel, I have a few thoughts about directions that this project may take. But to keep you awake and to keep you from leaving, I'm going to save them for the question period. Thank you very much.